Good morning, good afternoon, or good evening, depending on where you are. On behalf of the Teaching International Law Interest Group of the American Society of International Law, it is my great pleasure to welcome you all today to our webinar, Preparing Future Generations, the Role of Technology and Learning International Law. In Teaching and Learning International Law. Integrating technology into education leads to numerous interactions among many elements. These interactions vary and grow with the diversity of the legal discipline and technological applications, as well as with their continuous development. There are many varied opportunities, challenges, and concerns in this regard. These can include the following elements: undergraduate and postgraduate programs, professional and career development programs, teaching legal and non-legal professionals, and skill-oriented programs, an increased emphasis on graduate specifications, employability, learning outcomes, and other quality assurance requirements, the variant requirements of educational environments, whether on campus or online, as well as differences in the capacity of educational institutions and in circumstances such as war, peace, or epidemics. The growing emphasis on pedagogical components such as curriculum design, legal skills, and knowledge production. To discuss all this, it is our great pleasure to have our guests today, a promising panel of distinguished scholars and practitioners to share their valuable insights and expertise on the technological interaction with the pedagogy of international law. Before I introduce our speakers and give them the floor, I would like to mention some quick housekeeping rules. First, please can attendees be mindful of keeping themselves on mute so that we can hear clearly. Second, we will be dividing the first 40 minutes amongst our honorable speakers and dedicating the last 15 minutes to discussion and final remarks. Lastly, I would like to ask the audience to kindly write their questions or comments in the chat Q&A box, and we will address them during the Q&A part of this webinar. Our first speaker is Dr. Kabir Duggal. He is a preeminent international arbitration and public international law practitioner, serving as senior fellow and advisor at Columbia Law School's Center for International Commercial and Investment Arbitration, CICIA, and a partner in Akin Gump's New York office. Recognized as a chartered arbitrator and certified mediator, he has served as arbitrator in over 70 complex investor, state, and commercial disputes across multiple jurisdictions and industries. Frequently acts as an expert on international arbitration and public international law matters, and has contributed to shaping global arbitration standards. He is a lecturer in law at Columbia, an adjunct professor at Fordham, and course director for the Columbia Law School CIR Comprehensive Course on International Arbitration, with over 60 publications, multiple books, and more than 400 speaking engagements worldwide. Kabir, the floor is yours.
Thank you so much, dear Khadija. Delighted to be here, delighted to be with a lot of friends on screen. And we're talking about a very fluid topic. Now, my friend Helen, who you see on the screen, is in London. And if you go back to the 1890s, the big problem in the city of London was horse manure, horse poop, right? Everybody went in on horses everywhere. They say there were like over 300,000 horses in London. And this was the big existential crisis. What do we do with all this horse poop? And guess what happened? The problem became moot because of the advent of cars, because of technology. And we're in a similar horse poop moment in our lifetimes, right? AI, about 2 to 3 years ago, this is it has existed, but its takeoff in a big way really happened in 2022 when ChatGPT started doing things that ChatGPT's creators didn't know it was going to do. And this is the issue for all of us who are involved in academia, right? Uh, the very famous line, right? AI won't replace lawyers, but lawyers who use AI will replace lawyers who don't. This is a slightly better version that AI won't replace lawyers, clients will, because you don't need lawyers. Let's not go there. That's terrifying. But it is our job, it is our task as educators to make sure people who are coming up know the right skills, the challenges that technology presents. So, when this topic was kindly presented to me by Kadeja, I gave it some thought. And I'm going to give some suggestions of how we can integrate AI technology in our process, just generally. I'll give some of these suggestions, some of these points. Some of them I have adopted, some of them you have forced me to think long and hard. And so hopefully I will incorporate them. One area, look, I'll give you the examples for my practice area, which, like Helen's practice area, we do disputes in primarily focusing on arbitration, but I think a lot of this could apply to public international law more generally. So, you know what I'm saying? Don't let my specific example take away from the broader point. The first way I think we can use technology is to train students, particularly when you're doing seminars, practicums, the smaller courses that are much more interactive. Use technology to tell your students to build case theory, right? Often we would give people papers and tell them we're going to use this as a case throughout the seminar, throughout the semester. Different aspects we focused on different parts of the simulation. We now do that on technology, and that's exactly what AI is telling us to do in real cases. It's good for us to start incorporating that young, right? They always tell when you get them young, and that this is true for religion, this is true for good and bad habits, right? When you get them young, you get them, right? One area that technology has proven to be very successful is when it just comes to document production, evidence handling. You can really streamline that process, right? In most of our cases, public international law generally, but definitely true for arbitration, these are document heavy. You can really streamline the process. So, giving students the skills to really be able to draw on these devices, right? What can it do? What can it not do? Uh, Giving those life skills. Another great area now, I am from the generation that we did this with. This seems like dinosaur technology, but paper and pen, right? We mapped out cases, right? So when you were studying a particular topic, right, you would map out, say, if you're talking about jurisdiction, right, you would map out cases favorable, cases against, you would do case mapping. You can do that all on technology now, right? And the good thing about technology, unlike paper and pen, is you can hyperlink things. So you can actually link it to the actual decision, which I just think makes the experience richer. Uh, Another area, and again, this is, when we're talking about life skills, right? The academy has moved towards very practical trainings, and getting advocacy skills through technology is phenomenal. Chat GPT, and I say this from personal experience, is a wonderful counselor. So if you have life crisis, talk to Chat GPT. It helps. But this is something we can all also play with, right? When you have to do an opening statement, when you have to do a cross examination, you can have it test your script. Now, there are lines as to where you want technology to play, and I'll leave that for the Q&A or for my other esteemed panelists. This is an area where we can incorporate technology. And the final point, when it comes to the final award, we can really identify appropriate places where technology can play a role. Now, to be fully clear, we do not at this point want AI to be writing an award. A stage may come when all disputes can be done by AI. The American Arbitration Association has created an AI arbitrator, which, for people who do this, it is fantastic and terrifying at the same time. But I still think we are not there as a society yet. Till we get there, we should be identifying what role can technology play in simplifying award writing, in decision making. There's a lot of potential here. We are really at this pivotal moment. And if we don't embrace technology, technology is not going to stop. It's still going to go ahead. Khadija, I promised you less than 10 minutes. I hope I respected my word. I will stop here and pass it back to you so you can carry forward the discussion. This is such a rich topic.
You still have like 3 minutes, Kabir, if you'd like to.
I will give the topic to my dear friend Helen, who,
Okay.
I've seen her notes and I wish I was half the man she was. She took so much effort and seriousness in doing this. So I will give my time. I will cede my time to Helen.
Thank
Thank
you.
you. Thanks.
Thank you, Kabir. Now it is my pleasure to give the floor to our second panelist, Vinicius. Vinicius is a PhD student and Master of International Law at the University of Cambridge. He is a Gates and Chevening Scholar. He researches international humanitarian law, and the protection of persons during wartime. He is also a federal prosecutor at the Brazilian Federal Prosecution Service, working with human rights and international federal crimes. Vinicius, the floor is yours.
Thank you so much. Firstly, I would like to thank ASIL for this webinar and to our host, Dr. Khadija. And if I may, I'm going to share my screen because I have sources. Because as an international student, and I hope everybody's seeing okay. So as an international student, and especially someone who did the master, now it's going to my second year PhD, I think there were some tools and texts that helped me a lot. So in this presentation, I'm going to show especially to the student, how we should collect and catalog our data, how to research general international law, and then I'm going to do some examples with international humanitarian law, international human rights law, and some final recommendations. So firstly, I would like to say that if you're doing any kind of study, today you're going to read Foucault, Habermas, I'm going to read Hannah Arendt. Please restore what you're reading, please sum up, please write, resume, because in the future, you're going to use that summary for a brilliant article that you're going to write. So think about initially when you're doing your first steps as a researcher, where are you going to store your data? Word, Evernote, Microsoft OneNote. But moreover, there are some software currently that helps us students, because in the older days, we had to do everything by hand, our citations. Now you have Zotero and Mendeley to manage your citations and to manage the PDFs and the cross-referencing citations. So in this initial step, I would like to say, think about where you're going to write your summaries, your resumes, but don't forget about the citations. You downloaded it. We love downloading PDFs that we are never going to read, but when you download a PDF, collect the DOI or the ISBN in Zotero and Mendeley, you're going to have your citation. If you're like me, or a student, English is not your native language, another software that's going to help you a lot is Grammarly or any other software that's going to, when you're writing Word, for example, it shows this is not the preposition at, it's in, it's on. So try to think about some softwares that help you when you're writing your initial research. But now moving to the specific part of general international law. The first thing is the primary sources. as a student, where do we find those primary sources? If we're looking into newer treaties ever since the 1945, the UN Charter, you're going to have the amazing UN treaty collection. In it, you're going to find this database of the United Nations, where you can find the signatories, the parties to the treaty. And if you're looking up into older treaties from the 17th or 18th century or 19th, I would suggest you go into the Oxford Historical Treaties. But if you are also aware that under the Vienna Conventional Law treaties, you're going to have the preparatory works to interpret a treaty, you can also check the UN library and ask them about the preparatory works of a specific treaty. And I cannot say thank you enough to the UN librarians that helped me a lot in my master's and now in my PhD. So the librarians usually will not only give you the preparatory works, but other documents that will help you in your research. And of course, when you're dealing with treaties, try to look up into the ICJ judgment, separate opinions, the ICJ website. But if you're also doing archival work, Harvard and Yale, they have different projects. And specifically in my case, I had to research the Nuremberg trials, and the Yale Avalon project had the Nuremberg trials, the archives, the testimonies of the witnesses, and the testimonies of the defendants. So it's really good if you're doing archival work, try to look up into specific universities and their projects. But let's say you know your treaty, your primary source, but you're still confused about the topic. The UN Audiovisual Library, they have specific courses, audio and visual courses that amazing international law professors are teaching about specific subjects. For example, today you're going to research about the law of the seas. In the UN Audiovisual Library, you're going to find professors teaching you the basics or specific courses, specific themes. And I also suggest to students to check the main international law journals like or AJO, American Journal of International Law, European Journal of International Law, Leiden Journal of International Law, because most of those journals or the universities, they have also blogs where you can be updated about what's currently going on in the world or a specific thing applied to a modern or a controversy like EJO Talk, Just Security, and other blogs. And as an example, ASIL has the international legal materials where you can also draw up on your research. And another amazing thing is the encyclopedias, the Oxford and Max Planck Encyclopedia of International Law, where you have a specific subject into depth. For example, you have the principle of distinction or proportionality, international humanitarian law. Then you're going to have the encyclopedia where cases, jurisprudence, and henceforth. And also the Oxford reports on international law, where you can find a lot of documents in international law. Going to my two specific research, which is international humanitarian law, international human rights. Whenever you are researching a specific branch of international law, try to think about the institutions that apply that branch in practice. For example, we all know that in international humanitarian law, the Red Cross is the main institution that not only has this amazing database regarding armed conflicts and specific commentaries to the Geneva Conventions, but the ICRC, because it's focusing towards the practitioners, laymen, and lawyers, they also have explanation of themes like the principle of distinction. So the ICRC database is going to give you the concept, where is it applied, and the jurisprudence. And it does also to sources, to customary international humanitarian law, and a sibling of international humanitarian law is international criminal law. If you're focusing on researching international criminal law, you also have the legal tools database for treaties and cases where a specific theme in international criminal law has been applied in jurisprudence. In international human rights law, I think the main rationale of trying to find an institution is applied. Because if you think about the main treaty, they also have an institution that applies those treaties. For example, the American Convention, you would have the Inter-American Commission and the Inter-American Court, the European Convention, the European Court, and you also have the UN agencies and UN bodies that apply specific conventions. For example, Women Convention, you would have CEDAW. So try to find the institution, because most human rights institutions or UN agencies or regional institutions, they have amazing database with applying a specific theme. For example, LGBTI rights. The Court has a publication of LGBTI rights, Inter-American System of Human Rights. And if you are teaching or researching, the European Court has added the European Conventions on Human Rights in practice. It's a teaching resource that's amazing for students. And my foundations are these two amazing guides for any student that's doing initial research in international law. Firstly, the Essex University website that's going to tell you about the methodology, and also a professor from Harvard, Elias Lieblich, article, How to Do Research in International Law, a Basic Guide for Beginners. Not stress enough how this article is important in my journey as a PhD student, because it not only distinguishes methodology from method, but once you go into primary and secondary sources, where you find those sources. So those two, the Essex University website and this article, for example, were the two main sources when I started my journey as a researcher in international law. So I would like to say thank you to our host, and I don't know who's going to be third now. I'm sorry, but any questions, please send me an email or do also in the Q&A. Thank you so much.
Thank you so much, Vinicius.
Let me just see how I stop the...
It is with great pleasure that I give the floor now to our third speaker, Helen Lofer. Helen is a legal academic and qualified solicitor advocate in England and Wales, specializing in public international law and international dispute resolution, with a strong focus on teaching and research. She's currently completing a PhD in law at the University of Cambridge, where her research examines the protection of foreign investments during armed conflict. Since 2023, Helen has taught general international law, international investment law, and international dispute resolution at undergraduate and postgraduate level at the University of Cambridge, and serves as a visiting lecturer at the University of Bucharest, where she convenes an LLM module on international arbitration. She is also a consultant editor of the Cambridge International Law Journal, and her recent academic work examines the role of technology and emerging duties of technological competence and international dispute settlement. Helen, the floor is yours.
Thank you very much, and thank you to the American Society of International Law and the organizers for the invitation. It is a real pleasure to join the discussion and to build on the important points already made about technology, teaching, and learning in international law. And I would like to add a perspective drawn from the practice of international law, which is why in my remarks today, I will focus specifically on international dispute settlement rather than international law more broadly. My intervention is structured around two closely linked propositions. First, that technology has become indispensable to the contemporary practice of international dispute settlement. And second, that because of this reality, the significance and use of technology should be integrated into the teaching and learning process from the very beginning of students' legal studies, rather than being treated as a specialist or optional topic. I will begin by narrowing the discussion to international dispute settlement, and I will then outline how technology is used in practice today and why it matters. Finally, I will link these points to legal education, offering a few brief examples of how technology can and should be embedded into teaching from the outset. When we speak about international dispute settlement, we are referring to a range of mechanisms such as international arbitration, including investment treaty arbitration and interstate dispute settlement. These processes differ in important respects, but they share several defining characteristics. First, they are inherently transnational. Parties, counsel, tribunals, witnesses, experts are often based in different jurisdictions, operating across multiple legal systems and time zones. They are procedurally complex, involving detailed procedural rules, extensive written submissions, and structured evidentiary phases. And they are typically document and evidence intensive, often involving vast quantities of factual, technical, and expert material. Now, these features mean that international dispute settlement has always been shaped by developments in communication and information technology. What has changed in recent years is not merely the availability of new tools, but the extent to which technology has become structural to how disputes are conducted. Technology is no longer a helpful accessory to international dispute settlement. It's become a condition of its possibility. One of the most obvious areas in which technology plays a central role is case preparation and document management. International disputes routinely involve tens or hundreds of thousands of documents, including contracts, correspondence, internal records, and technical reports. And technology is used to collect, store, search, and review these materials through sophisticated document management and e-discovery platforms. Importantly, technology doesn't merely make this process more efficient, it shapes how lawyers conceptualize the case itself, including how factual issues are framed and prioritized. Without such tools, many contemporary international disputes would be practically impossible to manage within reasonable time and cost constraints. Technology also plays a crucial role in fact-finding and the use of expert evidence, which is a defining feature of many international disputes. Experts in areas such as energy and construction increasingly rely on digital modeling, data analysis, and simulations. These technological tools are used to quantify damages, reconstruct events, model technical processes, and visualize complex factual scenarios. Tribunals, in turn, rely on these outputs to understand and evaluate highly technical evidence. As a result, technology influences not only how evidence is presented, but also how it's assessed and weighed. This has important implications for advocacy and decision-making. Effective engagement with expert evidence today often requires a degree of technological literacy, both to understand the underlying methodologies and to communicate them persuasively. Technology has also transformed the procedural conduct of international disputes. Remote and hybrid hearings, once exceptional, have become routine. Procedural conferences are regularly conducted online, and case management is increasingly handled through digital platforms. These developments have enhanced accessibility and internationalization, allowing participants from different jurisdictions to engage more easily in proceedings. At the same time, they have reshaped advocacy. Presenting arguments, examining witnesses, and engaging with tribunals in virtual or hybrid settings requires different skills from traditional in-person advocacy. Technology therefore affects not only the logistics of proceedings, but also the practice of procedural law itself, including how procedural fairness, efficiency, and equality of arms are understood and operationalized. Finally, technology is deeply embedded in legal research, as my colleagues have just highlighted, and strategic decision-making. Counsel rely on digital databases for treaty interpretation and increasingly draw on data-driven insights when making procedural and strategic choices. Technology shapes how lawyers assess risk, manage timelines, and advise clients. It influences how arguments are developed and how disputes are strategized. In this sense, technology affects not only how international disputes are conducted, but also how international dispute settlement is conceptualized and practiced as a legal field. Against this background, it's increasingly recognized that technological competence is not merely a practical advantage, but a professional responsibility. In international arbitration and dispute resolution more broadly, there is growing discussion about the existence of technological competence duties for legal practitioners. These discussions are reflected in debates about procedural efficiency, due process, data management, cybersecurity, and ethical standards. While the contours of such duties are still evolving, the underlying premise is clear. Lawyers involved in international dispute settlement are expected to understand and appropriately use relevant technologies. This makes technology a growing area of importance, not only for practitioners, but also for students, who are the future participants in these processes. Preparing students for international dispute settlement today therefore necessarily involves preparing them for a technologically mediated professional environment. This brings me to the link between practice and education, and to why these developments matter for how we teach international law. Despite the centrality of technology in international dispute settlement, legal education has not always kept pace. Students may learn substantive law and procedure in a largely abstract way, with limited exposure to the technological contexts in which these rules operate. This creates a disconnect between how international dispute settlement is taught and how it's actually practiced. The issue is not that students lack technical skills, but that they may lack an integrated understanding of how law, procedure, evidence, and technology interact. Integrating technology into teaching from the start is not just about turning law degrees into vocational training programs. It's about enhancing conceptual understanding. Technology provides a framework through which students can better grasp procedural dynamics, evidentiary reasoning, and institutional practice. One way to achieve this integration is by using technology to teach procedural law. Instead of presenting procedural rules solely through lectures or readings, students can work with simulated digital case files, procedural timetables, and document production exercises. This allows students to see how procedural decisions are made in practice, how they interact with evidentiary issues, and how they shape the trajectory of a dispute. A second way to integrate technology into teaching is through the way we approach evidence and expert engagement in international dispute settlement courses. Rather than treating evidence as a purely doctrinal topic, students can be exposed to how factual and expert material is actually generated, organized, or evaluated in practice. This can include working with anonymized expert reports, simplified datasets, or visual representations of technical evidence, and discussing how such materials are presented and challenged in practice. This approach helps students understand that evidentiary reasoning in international dispute settlement is not abstract, but closely connected to the technological tools used to analyze and communicate complex information. It also encourages critical thinking about reliability, transparency, and persuasion in a digital evidentiary environment. And a third example relates to the integration of technology into teaching professional skills and ethical awareness. As discussions around technological competence gain traction in the international arbitration and dispute resolution sphere, students should be encouraged to reflect on what it means to act competently and responsibly in a technologically intensive practice. This can include consideration of issues such as data management and cybersecurity. Embedding these questions into substantive courses helps students see technology not merely as a technical matter, but as part of a professional judgment and as part of responsibility. It also prepares them to engage critically with evolving expectations of competence in international dispute settlement. To conclude, technology is no longer peripheral to international dispute settlement. It's embedded in every stage of the process, from case preparation and evidence to hearings, advocacy, and decision-making. It's also increasingly recognized as a matter of professional competence and responsibility. If we want students to understand international dispute settlement as it exists today, rather than as it existed in the past, technology must be treated as a core component of legal education and not an afterthought. Thank you very much.
Thank you so much, Helen. Finally, I now give the floor to Raneem Asad. Raneem Asad is an international dispute lawyer advising and representing states, state-owned entities, and corporations in complex high-value investment treaty and commercial arbitrations, with a focus on the construction and energy sectors in the Middle East. She has assisted the former judge of the International Court of Justice in cases before the court and in several international arbitral proceedings. Her experience also extends to cross-border litigation matters, wherein she advises on procedural and substantive issues involving multiple jurisdictions. Raneem also advises international organizations, including the European Union and the World Bank, on women's rights in the Arab world. Raneem holds an LLB and LLM in transnational law from King's College London. In 2016, Raneem won first place and received the Best Oralist in the Grand Final Award in the UK rounds of the Philip C. Jessup International Moot Court competition, later placing as a semi-finalist in international rounds in Washington, D.C. Raneem, floor is yours.
Thank you, and thank you for the kind introduction. and I thank the American Society of International Law and the organizers for the kind invitation to speak on a very topical matter, which goes to the core mission of the Teaching International Law Interest Group. In my remarks today, I'll be focusing on the accessibility and internationalization of moots related to the teaching of international law and how that intersects with the use of evolving technologies. I'll divide my remarks into three distinct yet interrelated topics. First, I'll address how the rapid increase of the use of technology in international law mooting has enhanced the accessibility of such moots as a platform for the teaching of international law. Second, I will address the positive and negative implications on the use of technology in international mooting for students in light of its educational objectives. And as a final point, I'll propose mechanisms on how we move forward, as it's very clear from the panels and my learned colleagues' observations that the use of technology is now inevitable, which makes it important for us to question, where do we go from here? So to begin with, the rapid use of technology makes it, as stated, an inevitable byproduct in any form of legal education and in the practice of international law. Its integration into international law education, and particularly mooting, that seeks to emulate such international law mechanisms of dispute resolution for students, is thus ever more important. As a practitioner myself, I recall the significant change that occurred during COVID, when practitioners suddenly went from organizing traveling for hearings ahead of time in international arbitration to suddenly having to collect themselves on these international platforms where we heard lawyers and we heard witnesses. Since then, it has become an option to conduct such proceedings online as a much more efficient and effective form of dispute resolution to gather people from across the world and solve international disputes. As a result, it's important to integrate that form of dispute resolution, that tool for dispute resolution, into the education of students. Mooting itself is a method for students to learn practice while still at university. Thus, it is inevitable that any good legal education, any good teaching of how to present during how to participate in international mooting also integrates technology in the same way that it would be integrated in international dispute resolution practice. And it's a reality now as well. Major international competitions such as the Philip C. Jessup International Law Moot Court Competition and the VISMoot have integrated virtual platforms to facilitate global participation. That includes video submissions and online oral rounds. This has a number of benefits. First, it enhances access and participation by reducing barriers, whether financial or geographical. Virtual platforms such as video conferencing and communication tools enable students, regardless of location, to participate meaningfully in moots. I, for one, benefited from being in a university with a rich mooting culture, which meant that we were sponsored when we needed to travel for moots. We were provided with all resources necessary to enable us to participate in these international mooting competitions. Other universities do not have that benefit, and we've all heard stories of students having to scramble to find sponsors to be able to attend these competitions, or otherwise not being able to attend due to these barriers. The reality is, technology means that more students can learn, more students can participate in international moots in a much more equitable fashion that has broken down those barriers. This also means that there would be widening participation in an international education that enables more students to hear about international moots, to be encouraged to participate in international moots that are the core of international dispute resolution education. And finally, this form of exposure, this form of broadening institutional participation also has practical benefits. It fosters authentic learning. By mimicking what students would be expected to do in practice in an international hearing. In this way, technology has enhanced the accessibility and internationalization of an international law education through mooting in a way that emulates practice and has effectively reduced barriers. But nothing is perfect. And I'll now move on to the positive and negative implications of integrating technology into international mooting. And before delving into that, we should all consider what are the main objectives of mooting in international law education. Mooting aims to transform students from passive learners of international law to active international legal advocates, which has a wide range of benefits and has a wide range of skill sets that students can acquire. First, through the mastery of international law doctrine by applying it in practice, through developing critical thinking skills and strategic learning, through developing research skills, written advocacy, and oral advocacy on the ground. Now, how are these skills enhanced or hindered through the use of technology? First, when we consider the concept of mastering international law doctrine, not just reading it on a textbook, not just listening to it in class, but actually applying it to a real case, which is what's required in mooting. How does technology help or hinder that? The reality is it helps. It helps you dissect cases. It helps you get access to information that you wouldn't otherwise have had access to. But in my opinion, it significantly hinders that aspect of international mooting education. And here I recall what a software engineer once told me at a dinner recently, which is, I feel sorry for software engineers because they'll never know how to use AI. And I found that to be a very paradoxical statement. But when I thought about it, I thought about my own experience, sifting through case law, developing legal arguments, thinking, how does this apply to this? And the reality is, if a student is unable to go through that struggle, how will they know how to ask AI the right questions? How will they know if the answer is effective or not? And this is where AI or technology in general can really be an impediment to legal education, and particularly in mooting, which is very practice-driven, very strategically driven. It will, I believe, hinder a student's ability to sift through problems and to apply international law doctrine through their own unique way of thinking, rather than the answer that ChatGPT may give them. And this also brings me to the next point, which is critical thinking and strategic and developing strategy. I think back to my time at the Jessup International Law Moot. Will we all have had the same answers if we just put our compromis onto ChatGPT? And I remember advice given to us once by the late Akil Nurali, my coach during the King's College, London. He told us to read the compromis every night before we went to sleep, and to read it over and over and over again. And the benefit of that was that we would notice something different each time we read it. And I found that to be true, and so did my teammates. But if ChatGPT or any other AI tools is doing the reading for you, how will you develop that ability to sift through information and critically point out the nitty-gritty of problems? That is where AI can be an impediment. And this is where future tools need to be developed in legal education to stop AI from being the impediment. And I'm aware that I spent a lot of time talking about the negatives, but there are positives. AI and technology in general has helped legal research. It has helped written advocacy. I recall the nights that I spent with teammates cutting down words, fixing citations, brought to tears as we argued and were unable to agree on what to cut down. Finger pointed, no, you should have done your citations more tidily. Your citations are not consistent. I look at back at that now and laugh, because it wouldn't have even been a problem. And yes, we may lose that bonding experience, but it would have made us more effective written advocates. So And the use of technology would have meant that we would have had to spend less time begging for ID cards to get into other libraries to try to get to rare books. There are a lot of benefits, and the benefits can enhance legal advocacy and really the educational aspect of mooting through giving us that broader access, through making sure that we don't get bogged down with small details and really get to the heart of what legal learning is. However, we need to be very cautious about how we move forward, because there are negative implications to what it means for an international mooter and a future international practitioner to be dependent on technology in a way that can hinder their development. And I'm conscious of time, so I'll just sum up my final points when it comes to moving forward. How can we use technology to facilitate and not hinder international education through mooting? That brings up a number of issues. The first is we can adopt international hybrid models, and we can adopt them not only in a way that, some moots use them, some moots do not, but rather we can market it. We can go to students and tell them that it's now easier for you to participate in international moots. There are less financial barriers. There are less, it is now much more equitable. And it's literally at your fingertips. And in this way, we can welcome a new generation of international mooters and future international law practitioners and create a much healthier community. However, we also need to question what it means, whether we want to introduce safeguards into international mooting that would prevent unfair advantages and still retain the benefits of what it means to be an international mooter. And I'm conscious of time, so I'll hand it over to the next speaker. Thank you.
Thank you, Ranim. We will now open the floor for questions and discussions. Until we get questions from the floor, I think I can start with some questions here. Do I do the individual questions or go with the what's for everyone? I think I'll do both. I'll just say my questions. For Helen, please, I think. Helen, if you had to recommend one concrete way for international law teachers to integrate technology into their courses without overhauling the entire curriculum, what would it be? I think I would just go with, sorry, yeah, please go ahead.
Yeah.
I just thought, do I go with the round of questions first before we get the answers, or
Sure.
Whatever you suggest, I don't mind. Everything is okay with me.
I'm happy to answer this question very quickly. Thank you for asking it. One very effective and low threshold way is to integrate technology into the teaching of procedure rather than adding a separate component on technology itself. For example, teachers can use digital case materials, online procedural timetables, or short simulated exercises where students make procedural decisions based on electronic filings. And this requires minimal structural change, but immediately helps students see how law, procedure, and evidence interact in practice. Even small steps like this can significantly deepen students' understanding and better reflect the reality of international dispute settlement, while remaining fully compatible with existing curricula. So the point that I'm trying to make is, I don't think that an overhaul of how we teach international is necessary. It's rather, what I would suggest is reconsidering how we teach international law and integrating technology where feasible and appropriate.
Thank you, Helen. I think this is a question for Kabir. Kabir, how does technology take us beyond the classroom's limitations? I can think now about curriculum design, assessments, but what about knowledge production? How does technology take us beyond these limitations within the classroom with regard to these elements?
Yeah, I mean, Khadija, this is such a great question and a deep one. because I think in many senses, technology can bring us closer. Look, there was a time when you needed money to be able to get access to knowledge, right? If you had to attend a conference, you had to travel. And to be able to travel, you needed to have money. You needed to have the right passport. You needed to have, right? Technology, in some senses, is an equalizer. I mean, look at us. We're all in different parts of the world. We're all with different backgrounds, but we're able to engage. Now, look, we're still assuming, and this is an assumption and one with privilege, that no matter where you are, you need to have access to a good computer, right? We shouldn't lose sight of that, to good internet. But putting that aside, technology has been wonderful because I think it has brought us closer. It has allowed these dialogues. It has taken away the elite status that only allowed few, and few with money and privilege and the right passport and the right skin color, to gain access. So I'll just stop there. But for me, this is so important.
Thank you so much, Kabir. Thank you. I think I will share now. I have a question. Maybe this one I'll share it with you all, and I'm happy to take whatever answers. How does the integration of technology into the pedagogy of international law prepare students for their country's development priorities? This question also raises how to move technology from a tool to a deeper level of empowerment, and how to address power structures, economic, social, regional. Consider, for example, the concerns and needs of the global South and those of the global North. I think it's a bit relevant to what you have been saying now, Kabir, but maybe a bit expanded. So any thoughts on this? Thank you.
I'm happy to take this if everyone doesn't mind. So what I recall the difference in my legal education in the UK as opposed to the legal education of people who I now work with in Jordan. We both had very different experiences in our international law education. And one of the most enriching experiences that I had was mooting, because it was the closest to practice, and it was the closest to giving a student the confidence that they need to move forward through the world, to speak up, to develop arguments, to point out issues, and to find solutions. The reality is, in the Middle East, most students did not have that exposure. And the reason that they did not have that exposure is because they didn't have access to it. There are international mooting competitions that are taking place in Washington, D.C., that are taking place in Paris, that are taking place in London, that not all students can afford to nor are encouraged to travel towards. And the reality is there is that disparity between the Western world and the global South in something as simple as international mooting competitions. Technology, as Kabir correctly stated, is an equalizer because it removes that barrier. And it relates to your important question, Khadija, about the future development of your country. If you are able to participate in these moots, you're able to work with future practitioners in various countries. You can meet the future foreign minister in Argentina, and you can understand how they think, and you can understand how their country develops, and you can gain the confidence to then develop the skills to do so in your own country. So I think your question is very, very topical, and it's actually a very exciting one, because it points out the real impact of what technology means in something as simple as international mooting and in international practice. Thank you.
Thank you, Reneem. Vinicius, please go ahead. Thank you.
If I may respond also about the linguistic barriers that technology has helped us in the global south. If you're not from a country that English or French is your first language, then it's quite hard for us coming from a global south countries, because not only learning English and French is a class mark because you are privileged to learn those languages, because I was saying in Brazil, the majority of Brazilians only speak Portuguese. To learn English is something also that you have to go further in your education. But I think technology, especially the AIs currently, and the AI in dictionaries are helping us how to search in international law, how to overcome that linguistic barrier. So I'm quite prone, because I'm seeing students here in Brazil having access to English and French texts translated into Portuguese, and that is helping us a lot, because the primary sources, let's be honest, they are mainly produced in the global north, in editorials and journals in the global north. So I'm quite prone to that.
Thank you, Vinicius. We have like 2.5, 3 minutes. Any other thoughts, Helen or Kabir? Okay, I think I'll just give one final question before we can conclude this session. And again, this is for everyone. When discussing the technological aspects of international law pedagogy, how do we handle this in high-risk environments, such as war zones, particularly given the vulnerability of digital communications in those settings? Any thoughts in this one? Thank you.
If I may offer two thoughts, dear Khadija, because that is such a real topic in the world that we are in today. Now, look, we know technology has been an instrument to fuel hatred. So that is a real cause of concern. We really hope there that as educators, we can inform regulators to control that. But hatred towards minority, spreading false information have all happened through technology. It's Telegram, WhatsApp, X. At the same time, technology does have this wonderful potential, right? You see kids who were in war zones and who had no access to anything, no schools, were able to continue education online, right? For me, technology is it's an instrument. It is on us to try to see it, particularly for us who are committed to education, to try to leverage this education into a positive as opposed to the negative.
Thank you
If I
so
may,
much. Please, a brief
if I
one.
may add just
Helen,
a
thank you
couple
so
of
much.
words.
Yeah.
Thank you very much for that, Kabir. I would like to add just 2 points. First of all, I was very pleased to notice, I'd say in the past 5 years, with the occurrence of unfortunate armed conflicts or development of armed conflicts, that technology enabled students to continue their legal education. And I think that's a benefit of today's age, which we should acknowledge. Yes, armed conflict is unspeakably disruptive to students' lives, but I was impressed to see students and professors' resilience in certain instances where, despite the unfathomable circumstances surrounding them, they carried on with their legal educations with a great deal of dedication. And the second point, which I'd like to make, is slightly different, but it relates to the teaching of international law. And this is something which I think my colleagues will be able to confirm. In more recent times, I have seen a lot of scholarship about how being able to see videos and direct evidence from conflict zones contradicts traditional interpretations of international law, or sheds light and increases awareness of how international law is applied or misapplied, and being able to experience in a more direct way the application and enforcement of international law and the diplomacy surrounding it, I think has been crucial to the ability to teach international law in an inclusive way, in a realistic way that integrates political theory with the teaching of international law. And I think that's something that we should be acknowledging today as well.
Thank you. Thank you, Helen. Thank you, everyone. I'm sorry, but I think that's what we have time for today. Today we listened to perspectives on technology and legal education through the lenses of dispute resolution, moot courts, international law classrooms, and legal research. However, there are many other areas given the vast scope and diversity of law and its interaction with our daily lives. These interactions have increasingly been shaped by technological engagement, and therefore any legal education, learning, or training cannot ignore this significant relationship between education and technology. By this, we come to the end of our webinar. I would like to thank all the panelists for their great presentations and for their time, and the participants for their valuable attendance. And I would also like to express my appreciation to ASIL. For those of you who are interested in more TILIC discussions and updates, please consider joining us in our LinkedIn group. I will post a link to join now. And we hope to connect with you again soon. Bye-bye. Just post the link, sorry.
Thank you all. It was great. And thank you, Khadija, for the excellent